Employee rights during disciplinary action. Employees have certain rights and protections during disciplinary actions to ensure fairness and prevent unjust treatment. It's important to note that these rights can vary based on the country and company policies. However, here are some common rights that employees typically have during disciplinary actions. 1. Notice of allegations. Employees have the right to be informed in writing about the specific allegations or charges against them. This notice should include details of the alleged misconduct and the possible consequences. 2. Right to respond. Employees usually have the right to respond to the allegations. This might involve providing their version of events, presenting evidence, and offering an explanation for their actions. 3. Right to representation. In many cases, employees have the right to be accompanied by a representative or a coworker during disciplinary meetings or hearings. This representative can provide support, advice, and advocate on the employee's behalf. 4. Access to evidence. Employees generally have the right to access the evidence that is being used against them. This allows them to prepare a proper defense and address the allegations effectively. 5. Fair and impartial investigation. Employers are generally expected to conduct a fair and unbiased investigation into the allegations before taking disciplinary action. The investigation should involve collecting evidence, interviewing witnesses, and considering all perspectives. 6. Timely and adequate notice. Employers should provide employees with a reasonable amount of notice before any disciplinary action is taken. This allows the employee to adequately prepare for any meetings or hearings. 7. Consistent treatment. Employees have the right to expect consistent treatment in disciplinary matters. Employers should apply similar disciplinary measures for similar instances of misconduct. 8. Appeals process. Many employers have an appeals process in place. Employees have the right to appeal disciplinary decisions if they believe that the process was unfair or the consequences were disproportionate. 9. Confidentiality. Both the employer and the employee have a responsibility to maintain the confidentiality of the disciplinary process. Sharing sensitive information publicly could harm the reputation of the employee or the company. 10. Protection against retaliation. Employees are protected from retaliation for participating in a disciplinary process or reporting misconduct, as long as their actions were made in good faith. 11. Documentation. Employers should maintain accurate and complete records of the disciplinary process, including written notices, investigation reports, meeting minutes, and any relevant communication. It's important for employees to be aware of their rights during disciplinary actions and to review their employment contract, company policies, and local labor laws to understand the specific protections they are entitled to. If an employee believes their rights have been violated during a disciplinary process, they may consider seeking legal advice or contacting their human resources department for guidance.